Hello, Andrew Bethel, Bethel Law, where we talk estate planning, finances, real estate, and taxes, here with another video all on taxes. But today, I wanted to focus on what are the taxes that beneficiaries of either a trust or probate would have to pay, because there's going to be a lot of overlap between those two. So before we get into it, be sure to like, subscribe, share the video with someone who's irritated with paying taxes, like I know most of you are, and let's dive right in. To start, let me quickly list the taxes that we're going to be talking about. Income taxes, property taxes, capital gains tax, estate taxes, death taxes, and inheritance taxes. Now that's 6 taxes total, but 2 of them are actually the same thing, but you'll have to stick around to find out which one it is. To begin, let's start with income taxes. Pretty basic, you should know all about income taxes. It's the taxes that you pay on any income that you earn from your wages. Now, for a trustor, somebody who's creating a trust, or in a probate case, the decedent, where somebody has passed away, they're going to pay income taxes in the year in which they passed away. Now, someone else is going to have to file those income taxes on their behalf, whether it be the successor trustee for the trust or the executor or administrator in a probate situation. In either case, the decedent needs to pay income taxes on any money they earned during the year in which they passed away. However, what happens to the activity that occurs after date of death? Any activity that occurs after date of death is going to be activity attributable to the estate in question, whether it be a trust or a probate estate. In that case, all activity, income, and all that is going to be attributed to the trust or the estate's tax returns. Now, beneficiaries, anything they receive from a probate estate or a trust estate, it's not income tax to them. It comes to them essentially as a gift. It's not income taxes. However, if the trust or estate does earn income during the administration period, the trust or estate will need to pay taxes on that money. Now, trusts and estates, they're taxed at a much higher tax rate than we are as individual people. So, in most scenarios, what we do is the trust or estate will allocate that income tax burden to all the beneficiaries. Now, the reason they do that is because when I pay income taxes on my personal tax return, I'm going to pay at a much lower rate than a trust or estate would if they were to go about paying the taxes. So, in essence, the tax man's still going to get their due. It's just they're going to get more if they go and collect it from the trust, whereas they'll get a little bit less if I have to write the check. Now, me as a beneficiary does entail me writing them a check, but, at the end of the day, it's more money in my pocket. Now, to close the door on income taxes, though, we have trustee compensation and executor or administrator compensation. Under a trust, a successor trustee who administers that trust is entitled to receive fair compensation for their services as trustee. I've got a video all about how to calculate that. And under a probate, the administrator or executor is entitled to also receive compensation for their services as administrator or executor. Now, under a trust, the successor trustee typically takes reasonable compensation for their services, which most of the time comes out to about 1 or 2% of the trust assets. However, under a probate, the executor or administrator, their fee is actually set by the California Probate Code, because their fee is the same as whatever the attorney receives for their fees, which, if you'll recall from my video all about probate, attorney fees in California for probate cases are set by the California Probate Code, meaning no matter what attorney you go to, it's the same fee. And in this case, executor and administrators, they're entitled to that same fee the attorney gets. Successor trustees and administrators or executors, they turn around and report that compensation they receive on their personal tax returns, and then they pay income taxes on that money they received. The deceased person is going to have to file a tax return for the year in which they passed away, and that tax return will be filed on their behalf by the successor trustee or the executor or administrator. Now, they're going to pay income taxes on that money they earned up to date of death, but any activity that occurs after that point is going to be attributable to the estate in question, whether it be a trust or through a probate. Beneficiaries, anything they receive as an inheritance, they're not going to pay an income tax on that, but if the trust does have to pay some sort of tax, the trust can allocate the tax burden to each beneficiary proportional to their share, and thus, even though they're writing the check, they're writing a smaller check than the trust or estate would if it was writing the check on their behalf. And lastly, trustees or successor trustees and executors and administrators, if they receive compensation for their services, they're going to report that on their personal income taxes. Next, let's jump to property taxes. And I won't stay on this point for too long because I have a very long and, might I say, excellent video all on property taxes when it comes to California. To catch you up to speed, in California, you pay property taxes on your property value. However, the county can only increase those taxes by a max of 2% per year. California real estate grows an average of 4 to 6% per year, so the longer you've had the property, the more out of step the property taxes are going to be with the actual property's value. Now, when there's been a transaction with the property, there's going to be a reassessment of the property taxes. So if you sell it, the new owner is going to pay an increased property tax bill. However, if you pass away with the property in your name and you have people inherit that property, whether it be through a trust or through a probate, then those property taxes are going to be reassessed unless the beneficiary falls within a certain category of exceptions. First exception that we typically see is a child of the decedent. So the person who passed away, if their child receives the property, they might be able to avoid a property tax reassessment, but under Prop 19, the only way to avoid that property tax reassessment is if the property was both the principal residence of the parent and the receiving child, or at least one of the receiving children if there's multiples. If we don't have those requirements in place, then full property tax reassessment on the property, which encourages people who receive property as an inheritance to turn around and sell it, so they don't have to deal with the increased property taxes. Second instance is a transfer from grandparent to grandchild. We can avoid a reassessment just like transfers from parent to child, but the only way to do that is if that intervening parent has passed away. So in essence, a transfer from grandparent to grandchild is the same as a transfer from parent to child. Same requirement of it being the primary residence of both transferor and transferee, the person transferring and the person receiving. But we just have to have the additional requirement that that intervening parent having passed away prior to the transfer. And lastly, the other exception we see is a transfer between spouses, which might sound kind of funny, but here, stay with me on this. Firstly, any transfers between spouses is an exempt transaction, so no property tax reassessment. So where do we have instances where a spouse is inheriting property of a deceased spouse? Well, the most common instance is, let's say only one spouse's credit was used in order to qualify for a loan to purchase a property. Now, when that property is purchased, it's only in that spouse's name, and they pass away before anything's done with it from there. Now, the other spouse is inheriting that property, potentially, and when they do so, no property tax reassessment because it would be considered a transfer between spouses. Now, the other instance of a transfer between spouses due to inheritance is one you probably maybe didn't think about, and it would be holding property in joint tenancy. Joint tenancy carries with it an automatic right of survivorship. I have a video where we talk all about that. And when one spouse dies, it means that their property goes all the way or automatically over to the other person. So then they have 100% interest in the property. That would technically be an inheritance, transfer between spouses of half the property, and thus we can avoid a reassessment because it is a transfer between spouses. The next tax we'll talk about is capital gains tax, and this is a big one. Now, I've done a lot of videos all about capital gains taxes and stepped up tax bases, so I'll try to go fast on this one. Essentially, capital gains tax is a tax on the difference between what you bought an asset for and what you sold it for. That purchase price is your tax basis. That selling price, well, the difference between those two is your profit. Now, when you sell your property, you pay taxes on the difference between your basis and your sales value. If you sell your primary residence, you do get a tax credit, meaning you need to make above a certain amount in profit, essentially, before you pay capital gains taxes. And that's $250,000 per person or $500,000 for married couples. Now, if you took your house and you transferred it directly to your son, for example, then when you do that, you're transferring over your basis in the property. So if they turn around and sell it for up here, your son is going to pay capital gains tax on the difference between these two numbers. However, let's say you kept the house and son inherited it. Well, now your tax basis is down here, but we throw it to the side. We don't care about it anymore because you get what's called a stepped up tax basis. So when son goes to sell the property, we no longer care about mom and dad's initial purchase price because the new basis in the property is now that value of the property as of date of death. And depending on how quickly they sell the property, that sales value is going to be probably the same number, which means from a tax perspective, they're going to report that they made no money on the sale of the property. In fact, they could probably turn around and report a loss after escrow, title, and the realtor takes their cut of the pie. With that, whether they receive the property through a trust or through a probate, they can turn around and allocate that loss to the beneficiaries just the same way that we allocate the tax burden to the beneficiaries. Now I hope you can kind of see the advantage there. We can allocate the tax burden to the beneficiaries so they pay at a lower tax rate. We can also allocate the losses to the beneficiaries so they can turn around and write off those gains using those losses. Now the next tax is estate taxes. And this is where we've got two things that are actually the same: estate and death taxes. They're one and the same. People just often use a death tax when they're trying to get kind of political and rile people up about it, but estate tax is the death tax. And for those who don't know, the estate tax is a tax on the estate. So whether it be a trust estate or a probate estate, that estate might have to pay estate taxes. So what determines whether we have to pay an estate tax? Well, it's going to be the value of that estate. And federally and in state-wise, we've got two different numbers to worry about. So for federally, if an estate is worth above the estate tax threshold, then we've got a 40% tax on anything above that number. Now I know we probably had some of you just cringe at the fact of a 40% tax, but keep in mind that that's a threshold, meaning anything below it, no estate tax is due. Anything above it though, estate tax kicks in. Federally, the estate tax does not kick in until the estate is worth, currently, $13.62 million, which is a very high number. Now that number is indexed to inflation, so it's going to get adjusted upwards again next year. However, it's only that high because of the 2017 Tax Cuts and Jobs Act, which the provision putting it that high is going to expire at the end of 2025, assuming Congress doesn't do anything about it, which, who knows, probably not though. That means in 2026 we're going to have a new estate tax exemption threshold, which we don't know what it's going to be because it's still indexed to inflation, but it's probably going to be in the window of about $7 million. Still a lot, but that's going to start lumping in a lot more people into that threshold group. Now there are ways to kind of avoid or at least mitigate estate taxes, but you need to watch my video all about portability in order to learn more there. Now that's federally. Let's talk state. Each state can assess its own estate taxes, and most don't. So if you're here in California, you're probably thinking, well, California definitely has an estate tax, right? Of course they're going to not miss an opportunity to tax you after you die. However, this is one instance where California is actually pretty nice. There's no estate tax in California. So if you pass away in California and your estate is worth above the federal threshold, at the very least, you don't have to worry about it from a state perspective. Now, there are some states that do assess an estate tax, some of which just copy the federal numbers, but there's a handful out there, looking at you, Oregon, that set that threshold way, way, way lower to where it's almost as if you got a house, well, now we're worried about an estate tax. However, if you thought the taxes on your death were all gone, we've got one more to talk about: inheritance tax. So the estate tax is paid by the estate, while an inheritance tax is paid by the recipients of an inheritance. Now for an inheritance tax, there's no threshold that we have to worry about. Instead, you either have one or you don't. So federally, there is no inheritance tax, which is great, but again, we have each state that can make their own rules. So again, you gotta check your state, but for us here in California, no inheritance tax to worry about. Again, California kind of lets you scot-free there. So with that, that's a broad overview of many of the taxes that beneficiaries under a trust estate or a probate estate do need to concern themselves with. Now, are there variations and exceptions and all that that can throw everything I just said out of whack? Well, of course, obviously. What would you need an attorney for if there wasn't? But all of those are very case specific, so it's going to depend on your particular circumstances. So let me know what you think. Do you think we should get rid of a bunch of these taxes, maybe do a flat tax or something like that? Or should we decrease that estate tax threshold and start collecting some money off of those wealthy landowners? Let me know in the comments below. I'm attorney Andrew Bethel of Bethel Law, keeping you up to date with estate planning, finances, real estate, and of course, taxes. Thanks for watching, and I'll see you at our next meeting.